Welcome everyone to the Center for Connected Health Policy webinar, Cross-State Licensure Court Cases. My name is May Kwong. I'm the Executive Director at the Center for Connected Health Policy, which is the National Telehealth Policy Resource Center. Next slide. A few disclaimers and friendly reminders before we begin our webinar. Please know that any information provided today is strictly for informational and educational purposes. It is not to be considered legal advice or legal counsel. We always ask that if you are interested in a formal legal opinion, that you consult with your legal counsel. Also know that if a certain product or a picture of a piece of equipment is mentioned, that CCHP has no relevant financial interest, arrangement, or affiliation with any organization. Please note that today's webinar is being recorded, and the recording of the webinar and the slides will be made available on CCHP's website about 48 hours after this webinar. Additionally, closed captioning is made available for today's webinar. If you look down at the toolbar at the bottom, you'll see a button that says show closed captions or show captions. You can just click on that and you'll be able to access that. We also ask that in our Q&A section that you please refrain from any political statements or advertising of products or services. We ask that you put any question for our panelists into the Q&A button. So you cannot raise your hand and ask your question verbally. You must utilize the Q&A button. We also will have an evaluation form made available at the end of the webinar that we asked if you would please fill that out. That would really help us for any future webinar topics and also any adjustments we may need to make to our webinars. Next slide, please. Just a quick background on CCHP. We were established in 2009 as a program underneath the Public Health Institute to actually be a California telehealth policy organization. However, an opportunity to become the federally designated National Telehealth Policy Resource Center became available through funding from HRSA in 2012. CCHP applied for that. We've got that funding and we've been serving in that capacity ever since. We also work with a variety of other funders and partners on the state and federal level on telehealth and connected health policy issues and projects. CCHP also acts as the administrator for the National Consortium of Telehealth Resource Centers, and we also convene a group in California called the California Telehealth Policy Coalition, which is interested in California state telehealth policy. Next slide. A bit of information about the National Consortium of Telehealth Resource Centers. It is made up of the 14 telehealth resource centers who receive funding from HRSA to provide technical assistance to basically the general public on telehealth in general. There are 12 regional telehealth resource centers that cover specific states and 2 national centers, one on policy, which is CCHP, and one on technology. I highly encourage everyone who have questions around telehealth to please reach out to their telehealth resource centers. As I said, there is a telehealth resource center that covers the state that you are located in. There are some resource centers that also cover some of the territories, such as Puerto Rico and Virgin Islands. So I, again, highly encourage you to reach out to them. They are some of the most knowledgeable telehealth folks in the country. Next slide. So for today's agenda, we are going to cover the 2 court cases that are pending right now related to cross-state licensure and telehealth. We have a great panel lineup for you today. And really our purpose for today's webinar is to give you some information on what's going on with those court cases, what they are about, and what we may expect in the future and the impacts of these court cases could have on patients and practitioners as they utilize telehealth. Next slide. As I mentioned, we have a great lineup today. We have Dr. Helen Hughes from Johns Hopkins Medical Center. We have Micah Matthews from the Washington Medical Commission and Caleb Trotter from the Pacific Legal Foundation, who is actually the counsel for the plaintiffs in the 2 court cases that we will be discussing today. And next slide. So without further ado, I'm going to first turn it over to Caleb to give us a rundown on these court cases and what they are about and sort of what are some of the arguments that the plaintiffs are making regarding licensure and telehealth. Oh, before we do that, my apologies, just to give you sort of a foundational setting here on what licensure is that we have both the federal on the state when you talk about telehealth policy impacting telehealth. But when you talk about licensure, licensure is a little bit different in that it is mainly within the state's purview to control exactly what happens with licensure. Now, on the federal side of things, there are a few areas where you will see the feds have oversight over licensure and in specific circumstances, such as if you are a practitioner operating within the Veterans Association or Veterans Administration system. However, they mainly defer to like what's going on in the states, and the states control it. You'll even see in like some of the federal programs, such as CMS with Medicare, they say we defer to what the states say about licensure. So that power is concentrated in the states for them to decide on what happens with licensure. And for the most part, states have said, if you're going to like practice within our borders, or you're going to treat a patient that's located within our borders, then you're going to need to get a license from us. And that's not just physicians, but really healthcare practitioners in general, the different types of practitioners, such as, OTs and PTs, nurses. A lot of our discussion today will focus on physicians, but the licensure issue does impact and go across different types of practitioners as well too. Now, they have created some exceptions or some avenues to allow like an out-of-state practitioner to like practice within their borders without having to get a license. But these are kind of rare and few exceptions, such as, a registration process or maybe like a specific scenario type of exception. Next slide. So some of the limited exceptions might be like if the practitioner is doing consultation with a practitioner that is licensed in the state, or if there's like an emergency. And the emergency, a lot of times you'll see language where it's centered around like if there's a public health emergency that's been declared. So, what one of the lessons of COVID is that you need to relax sometimes those licensure restrictions, just simply to like try to get services into an area that has a high need for them at a certain time. But we've also seen like policies in place where there are infrequent interactions. So a state may say, well, you don't need to get a license if you're only going to do maybe a dozen visits a year into our state, or if there's already a pre-established patient-provider relationship. And that's really to account for if somebody's traveling within the state for a temporary purpose, such as for work or vacation, or a lot of times if they're like a university or college student who has gone to a state for education, but they're not a permanent resident there. However, those are very, as I say, very hyper-specific types of scenarios, and they're kind of few and far between. They're not in all states, but we're starting to see more of them appear in states. Another type of exception they may have is a registration process or a telemedicine license. So instead of going through get a full state license, they have a registration process or specific telemedicine license they may issue. Or as many people may be familiar, are compacts. So compacts vary depending on what type of compact you're talking about, and compacts are focused in on individual types of practitioners. So you have one, for example, for physicians, for nurses, for OTs, PTs, and they're all structured differently. So you may have one you have one license from a compact member state, and you can practice in other compact member states without having to get a license from those other states. That's how the nurses compact works. Or perhaps it might be an expedited process where, well, you have a license from a compact member state and you can go through a quicker process to get a license from another compact member state. And that's the physician one. All these to say, like, these are the current existing type of licensure sort of routes that you can take here. You can get a license, like go through the full process, or you might be able to find one of these exceptions. The court cases are something different. The court cases are arguing that, this whole thing of requiring a license may not actually be constitutional. And now we will actually turn it over to Caleb and have him discuss and inform us about what are these court cases and what are the arguments that the plaintiffs are making. So Caleb, I'll turn it over to you.
Thank you, May. On this slide, you can see the name of both of our cases, McDonald v. Sabando and McBride v. Lawson. Those cases are currently pending, filed in federal district courts in New Jersey and California. I mean, you can see we have listed the legal claims that are brought in both claims. They're very similar. The New Jersey case has one additional claim. I'll get into that in a moment, but first, I think it'll be most helpful to really discuss and give an overview of the factual context that these cases present. To be clear, we are not seeking to declare state medical licensure unconstitutional and do away with it. That would probably get laughed out of court by any judge, I'm sure. They're much narrower than that. And so the group of plaintiffs that we represent are in both cases are groups of specialist physicians uh, who have national practices, work at specialty hospitals. These are the physicians that when a patient is diagnosed with a rare cancer or condition, and there aren't the local resources or expertise available, these specialists are who that patient is referred to. Oftentimes, um, they're out of state from the patients, and so because of that, it's fair to say that they truly have national practices. Some of them even routinely have patients from around the world, and so because of that, it's a reasonable situation that at some point down the line there could be a need for them to be licensed, maybe not in all 50 states, but a great many of states. And as I'm sure many of you know, that the cost and the burden to obtain a medical licensure in many states is quite burdensome. Someone actually did the math, and if a physician sought to be licensed in all 50 states, it approaches $90,000 just up front in application fees, background checks, fingerprints, all of that, in addition to all the various document gathering and things like that. And that's not even to mention the ongoing burdens of keeping track of various renewal dates, continuing education requirements, which vary across the state significantly. And so it's a real burden if a specialist physician who could see a patient from anywhere on very little notice needed to go about obtaining a license in every country. So that's kind of the perspective of a physician coming into these cases. For the patients, we represent a group of patients that were diagnosed with rare cancers and diseases, some of them as young children. And in the course of seeking treatment for these rare cancers and diseases, they learned that the resources and expertise were not available locally. And so they wound up needing to seek out expertise out of state. And some of them did this years ago before there were really much attention paid to this by regulators. Some of this occurred during the COVID period where states were relaxing licensure rules. And I guess maybe before getting ahead of myself, May kind of alluded to this earlier, but most states require a physician, even if they're simply going to use telemedicine to just speak with the patient, not using telehealth to provide treatment, but just have a conversation. If that physician is not licensed in the state where the patient is located, then that's illegal in most states. And so if you have, take our California patient, Shelley Horowitz, she has a very rare bleeding disorder. And she found out over years that the only physician she's been able to find with the
So I'm not sure if Caleb's having issues.
May, can you hear me?
Yes, there you are, Caleb.
It appears our office internet dropped. I'm so sorry, but I was able to get it on my phone. So if you can bear with the different background, I'm not sure where I dropped off, so my
You were just
apologies.
saying Shelly had a rare disease. That's where it froze
Okay,
for me.
okay, good. So it wasn't too long after I noticed. Um, So Shelley Horowitz, she has a very rare bleeding disorder. She's located in extreme rural Northern California along the coast. And after years of looking for the proper treatment, she came to find that the only doctors with the necessary expertise for her were located in Portland, Oregon. And so she had the choice of either driving 7+ hours each way to see these physicians or the potential to use telehealth to touch base with them when things came up, to allow her to lead a healthy, happy life. So that's just one example with our patients in New Jersey. Some of them were children, and their parents needed to very quickly seek out the proper care for them, regardless of where it was. And so by being able to use telehealth, they're able to very quickly kind of scour the country for the necessary expertise and not have to drive or fly around the country, where those financial burdens would quickly add up. But once the COVID experience was over, a number of states had relaxed these restrictions. Patients and physicians were left with, well, now I'm either going to lose my doctor or be unable to consult with an expertise, unless the physicians go about being licensed in every state. And so, with situations of rare disease and cancer, and this is obviously, I'm not being dramatic, but a matter of life and death. And oftentimes patients just aren't able to physically travel due to their health. And so this isn't the context that I think we're looking at isn't necessarily presenting a choice between an in-person visit or a telehealth visit. It's oftentimes presenting as a choice between a telehealth visit and no visit at all, and so losing out on physicians with the necessary expertise. And so when we got in touch with these group of patients and physicians, we came up with a plan that there were very real constitutional problems in a narrow as applied context. And so what I mean by that is what I said earlier. We're not seeking to take down state medical licensure in total. We're only looking at it as applied to an upfront consultation and then a follow-up conversation. So when patients are looking to find that doctor who can treat them in person, instead of having to fly around all over the country or drive just to find who that doctor is, being able to use telehealth, whether it's the phone or video, just to make sure that it is that physician can treat them. They can then, once they find that physician, then go travel for the in-person treatment. And then after that treatment's provided, use telehealth to follow up just to make sure things are going well. And so the piece in the middle, which is actually using telehealth to provide treatment, think talk therapy or primary care. Those technologies are available, but our cases are not going to implicate those aspects at all. And so it's just the initial consultation and follow-up conversations. And so as you can see on the slide, the claims we have, and I'll get through this a bit pretty quickly, as you can see them there, and then I'm happy to discuss it further later on in the discussion or Q&A. But I've tipped my hand since I've said that we're talking about consultations and follow-ups and that these are conversations, not actual treatment. That's why we have a First Amendment claim. Our argument is that is speech. Even though it's the practice of medicine, it falls on the side of speech that is protected by the First Amendment. And then the Commerce Clause and privileges and immunities claims, those are basically doing the same thing. They're saying that states are not allowed to erect legal barriers around the borders of the state to keep out of state businesses or professions. And when that's done, states have a very high burden to justify those laws. And then you can see in the New Jersey case, we have one additional claim. That's a due process claim. And that's because in addition to having
a minor as a plaintiff, we have his father, and there's a 14th Amendment due process right of parents to direct the medical care of their children. And so that's why we have that case in the New Jersey, that claim in the New Jersey case, but not the California case. And so that's just kind of a broad overview. Where the cases are now, they're the same place procedurally. The state medical boards have filed motions to dismiss, which is very commonplace in constitutional cases. And that's basically saying or arguing that even if everything the plaintiffs say as a factual matter is true, they just can't win on the legal merits. And so, judge, you should just dismiss the case now before even getting to discovery or a trial or things like that. And so both cases, we have fully briefed those motions, and we're essentially just waiting on a judge in both cases to decide whether to allow the cases to move forward to discovery or to dismiss them. If they're dismissed, we would likely appeal to the appropriate court of appeal at that point. But I will leave it at there to be respectful of time with my internet issues. So looking forward to continuing the conversation. Thank you.
Thank you, Kayla, for that overview and rundown. And thank you, everyone, also for letting me know that it wasn't me who froze. We'll now turn it over to Dr. Hughes, Helen Hughes from Johns Hopkins, who will give sort of more of a perspective on like what are the impacts on a practitioner, this whole cross-state licensure issue, and maybe what can be the impact on them depending on how these cases move forward. So Dr. Hughes? Dr. Hughes, are you still on mute? Wait, I can't hear you.
I was double muted. Can you hear me now?
There you go. Got you now.
Okay, great. Thanks so much for having me. I wanted to echo some of what Caleb said about the impact on our clinicians. So we have a lot of providers who are specialists who are taking care of patients who have a relatively rare condition. And so a lot of times people are coming either regionally or nationally. We also have researchers who are doing a lot of innovative work trying to cure rare diseases who have patients coming from all over the country or the world. And we, headquartered in Baltimore, we also have a pretty narrow geography: Maryland, DC, Virginia, Delaware, Pennsylvania, West Virginia. We can travel to a number of states within about an hour. And we also have hospitals across multiple states. We have hospitals in Maryland, DC, and Florida, and ambulatory practices in Virginia. So this is a pretty huge issue for our specialty providers, especially since they got the taste of how easy it was to do this during the first couple of years of COVID. As Caleb mentioned, it's pretty burdensome providers to ask them to just get licensed in multiple states, even if that pathway is somewhat easier. It can cost $300 to $500 per license. It can take 8 hours to do the paperwork and the fingerprinting, et cetera. So it's really not possible for a clinician to do that just to see a handful of patients in another state, especially when they can't predict, when patients are going to schedule with them, especially for new conditions. And then even if you take just the patients who are in the states that we already care for, people's location is fluid. We have students going to college. We have snowbirds, traveling south for the winter. We have people who are traveling for work or vacation, or people who need to move but want to keep their established provider. So it's just a really complex issue and definitely impacts our providers. What we'd love to see, and we really appreciate all the work of the advocates who are going forward with these cases, is that we're getting a little bit impatient with the state-by-state approaches. We think there's been a lot of great work done at the state level, but it's going to take a long time based on the current framework to see individual states pass common sense approaches. We've seen the Uniform Telehealth Act be considered, but I don't think it's yet passed in full in its entirety by any jurisdiction. And the complexity that May showed on that first slide of, I think you said 36 states have limited licensure flexibilities. It's really impossible for us to keep track of those, although we appreciate all the work that CCHP does to summarize it, and then to ingest it into our medical record in a way that people can actually schedule visits and receive care. For instance, Virginia has a great exception for established patients, but we actually can't get our medical record at this point in time to recognize that exception so that we can schedule a visit. So we'd really like to see something that's national and simple for these complex and rare diseases. For instance, let's say we take cancer care. It'd be very easy for us to say, for our cancer clinic in our electronic health record, those providers can be scheduled with patients anywhere in the country. That's something we can definitely operationalize. So we want to think about narrow use cases where there could be some national solution, like the VA approach or the Sports Medical Clarity Act. And then we were lucky in September, on September 19th, to have some grant funds to host an event at the new Johns Hopkins Bloomberg Center, which is our new domestic policy school down the street from the Capitol. And we had about 100 people join us, trying to think about these narrow use cases where there could be national solutions. I just want to play 3 minutes of a video that we were able to make for that, share some of the patient stories about why this is so important. And I think the team's going to chat the video link if you still have it, or I can chat it, and I'll just show 3 minutes of it as I wrap up here. It's part of the fabric of how we deliver outpatient. And then all of those waivers started to expire as state public health emergencies expired.
8 years ago, I was diagnosed with a very rare disease, and my doctors here in Asheville, North Carolina are very good. There's a cancer center, but they told me up front that I would need someone who specialized in my disease because they had read about it but had never treated it.
Specifically with this community, you know, we really rely on specialists, and they can be across the country anywhere.
To me, there's a difference between routine care, you know, and these unique situations.
So I was diagnosed with cystic fibrosis when I was 3 months old. I grew up seeing my doctors like my entire life. So the fall of 2020, I went off to college and got super sick, developed pneumonia, and went into liver failure. I was at the local hospital who wasn't set up to treat me because of the complexity of my condition.
There are urgent situations across our country, and we hear from our patients frequently, where patients are really needing to receive cross-state care today, and they can't because of state-based licensure rules, including cancer care, transplant care, rare diseases, college student mental health, and, you know, clinical trials from an innovation standpoint. And so we really want patients to be able to connect with their providers and with their families, regardless of geography, so they can get the care they need.
Here we were, my father just having had his first stroke, he couldn't function.
Eve is in San Francisco, Francois in Baltimore, Philippe in Florida. So the only way that they could have been involved, and their involvement was critical, was by Zoom.
Given that it's specifically a neurologic illness, Mark had a lot of questions at that time, and we really had to reiterate the information. Each of us, you know, kind of heard things in different ways and could interpret things a little bit differently and stress things differently. And so I think without all of us sort of being each other's backups, you know, on Team Mark, I think it would be really difficult.
To not have to actually fly across the country and be present in a meeting, which is impossible, right? I mean, the fact is, it means that one of us is sharing the information with the rest of us, and to all be able to be present in a meeting makes the most enormous difference.
In ways that could have been life-saving.
The impact on patients I would break into 2 categories. One is stress and psychosocial, and the other is logistical and a logistical burden. So from the stress and psychosocial burden, you have a rare condition or a life-threatening condition, and you live in the United States of America, and you want to have the access to the specialist who you feel is the best to treat your condition.
You know, there's a lot of hospitals out here, but when I went to Mayo Clinic, Cleveland Clinic, MD Anderson, Sloan Kettering, who diagnosed me for the 3rd opinion, UPMC, who did the 2nd opinion, yet when they were done, they had no clue what to do with me. They knew what I had. It's just hard. And to find somebody that knows what to do with me, you just can't imagine until you're in my shoes. You just don't know. And I can't be the only one that it's financially a burden or hard at 65 to drive 7 hours, but feel that you only trust this doctor.
What has struck me as a lawyer is
so I was asked to speak about provider and patient perspective. I think definitely our patients speak much better than I could to indicate, how impactful this is, especially for people with rare conditions. Yeah, so looking forward to the continued discussion.
Thank you, Dr. Hughes. We're now turning it over to Micah Matthews from the Washington Medical Commission. Micah.
Thanks, May. So I've been asked to talk about the various policy approaches and to touch on some complaint-driven enforcement aspects. So I'm just going to cover the timeline with respect to cross-state items, and I'll start with a slight clarification on the federal licensure discussion. The feds actually defer to state-based licensure. The difference here is that they don't require a license in every state or where someone's practiced. So an example, someone that's working in the Washington State VA could be licensed in Oklahoma. So the feds are still utilizing that state-based license, but they're allowing it to be portable within their particular geographic institutions. So onto the timeline, 2014 to 2016, state medical boards had been developing telemedicine guidance and policies, and that kind of spawned from the internet prescribing era, the Ryan-Hyde Act. And if you're familiar with that, there was a bit of a tragedy with respect to online ordering of narcotics from Canada. And so then about 2017 to 2019, the continuity of care licensing exemption started to get developed and promoted. The Medical Commission itself led that charge, both in the state level, but also nationally. And then from 2019 to the present, telemedicine practice, federal waivers, and the volunteer healthcare practitioner surges all occurred, where we started to see much more willingness of policymakers to be flexible in how we approach this. There was also some confusion in the beginning of the pandemic, where it seemed that the presidential administration didn't understand the role of CMS and what their authority actually could be. And that was demonstrated by the initiation of a number of waivers for CMS, and the folks that were announcing these waivers at the federal level were conflating the ability to treat CMS beneficiaries with licensure issues. And so there was a big dust up on that, tried to get them to correct and understand what their actual role was, and they did end up fixing that. And so going to 2022, the Federation of State Medical Boards adopted a new telemedicine policy that was based off of the Medical Commission continuity of care concept. At the same time, the Uniform Laws Commission was developing their uniform telehealth law, which incorporated those concepts as well. In 2023, we have the Dobbs decision, which I would argue, had that not occurred, there was a lot more willingness to be flexible with respect to not only state medical boards, but really the states themselves stepping in and drawing some very hard lines. I could speak to New Mexico, New York, states that I've had extensive discussions with, and their unwillingness to provide flexibilities because of the concern of what I would describe as anti-choice states, or states that have created structures that could punish physicians who, while operating in their own state, are apparently breaking the Practice Act of the distant state. And so there's a lot of concern among that, and I don't have a great solution to propose to them, other than you've got to create some shield laws. You have to make sure that you're protecting your licensees from the out-of-state bad actors. So with respect to that, Washington was the first state to pass the Uniform Laws Commission Uniform Telehealth Law. It defines telemedicine and establishes the standard for establishing a patient relationship via telemedicine. And then it establishes various scenarios for licensure exemptions. And those have been discussed briefly with, temporarily in another jurisdiction, follow-up specialist care, assessment, and diagnosis. And so I want to highlight that last piece, because that seems to be a lot of what Caleb's talking about and what Dr. Hughes is talking about. In our law, it is specific that you do not need to be licensed to have an assessment and diagnosis. We draw the line at treatment. And so you can have an out-of-state consultation. You can have that conversation. I'm not sure I would agree for a number of reasons that with Caleb's position that telehealth is simply speech there. And that's simply because there are so many potential negatives and harmful impacts that can occur simply through a telehealth consult, whether it is providing prescriptions, providing therapy, or recommendations that do not meet the standard of care. And I think the bottom line is most policymakers, and I think California is a big example in this, are not willing to give up the control over what is appropriate clinical medicine or appropriate practice for their licensed practitioners. And, with respect to California, that's one of the primary reasons that they are not part of the compact, even though they were instrumental in the drafting of the initial medical licensure compact. So moving to compacts, there's three flavors. You've got the expedited license, you've got the multi-state license, which is the nurse compact, and then you have the practice privilege, which does seem to be gaining quite a bit more popularity. The most recent to activate is the physician assistant compact, which I was at that meeting last week to stand that up. So nursing was the first, but I would say that the physician compact is probably the most successful at this point with respect to the number of states that have adopted it, implemented it, and those that are considering it. It's also embraced by the federal government, DOD, CMS. They have both made military-based siting decisions contingent on compact participation, as well as funding and military portability, which is obviously a very important thing for the military members. So the key things that I want to make sure people understand about compacts is this is the first time in history that state medical boards or other or other regulators have had a binding legal agreement with a legal hook between regulators that allows us to trust their process. Previously, it was just that the other state board was conducting their due diligence, you hoped, and with a compact, we can actually take them to court and hold them accountable. And I will point out, this is not an abstract issue. We see this in licensing every week. There are certain states that I won't highlight right now, but I've directed my licensing staff that if we get an application from someone from these certain states to use a little bit more scrutiny, because we have a history of those states not conducting competent processes. So it also solves to some degree the cross-state subpoena issue. And so if you're not familiar with that, that's basically if you're trying to find out something that happened across state lines, your subpoena stops at the border. There's no requirement, no acknowledgement sometimes that you can even get a subpoena to, say, another state medical board to get records on a jointly shared license. The compact solves that. It does require that subpoenas are honored. There are some intricacies with respect to post-Dobbs world where there are legal shields put up that say that in Washington, for example, you have to submit yourself to the jurisdiction of the Washington courts and attest that it's not going to that the subpoena does not deal with certain covered services, gender affirming care, reproductive rights, that sort of thing. And if you do misrepresent, you are subject to Washington jurisdiction per your attestation, and you're subject to $10,000 of a per violation. So with respect to how regulators work, I'm going to be very brief on this. We're complaint-based and we are jurisdiction-based. So that raises the complications of going across state lines. If we have a patient who files a complaint on a practitioner interaction that, say, happened at Dr. Hughes' facility, if they're not licensed, we have no ability to do anything. We just actually had this example with a detention center that's run by ICE in our jurisdiction, and the medical director, number one, applied for a license that wouldn't even allow him to do what he was doing, but he was licensed in Virginia, and it's not that it's a federal jurisdiction. This is a contractor with the feds on a private property, and they have shut us out from even inspecting the facility, despite well over 30 complaints about patient care and conditions. So it's not abstract for us because we see this every day. The only thing we could do was send a notice to the Virginia Medical Board saying, these are the complaints, these are the concerns, and it's your licensee. Good luck. And so that's one of the issues. And so I highlight that to say, by the potential of undoing the state-based regulatory system, the people that lose when things go wrong are the patients. Because, yes, driving 7 hours, traveling across the country, that is stressful, that is expensive. But when an actual harm occurs, whether it be through a misdiagnosis, delayed diagnosis, or simply just lack of action, it's the patients who are going to have to try and figure that out. And really the only fallback, and I have a lot to say about this, is the malpractice system, which is frankly not equitable. And so that's part of the issue there. With respect to the regulator role, for us, consumer protections is why it's important, to regulate licensure. The fact pattern of the specialty intervention and remote surveillance follow-up, it's not a concern as it's allowable in many jurisdictions, and more, every month they're picking that up. And as I pointed out, the FSMB model policy, the uniform law, and the medical commission has explicitly allowed this for years. So with that, the reminder is regulations are quite literally written in blood, and in medicine, it's probably more explicit than that. The concerns that the regulators generally have are more to do with the direct to consumer and venture capital based companies who are more focused on medicine than they are on patients. And so we already see, I already have complaints and cases that we've processed through that of telehealth companies that are preying on patients, and even the savvy patients who are not understanding what they're getting and what they're not getting. And, the end result is those patients end up presenting at the emergency department, and we end up with a complaint later from the patient or the insurance company. So I mentioned lack of jurisdictional clarity. And then finally, telemedicine, it's long been accepted as a modality of practice of medicine. It's not separate. It's part of medicine. It's just a way to deliver care. And so I will point out that crucially, the determination was made for that by the profession, not the regulators. The regulators went along with it. The profession decided that that's what it was. And it's the entire system is based on that concept. So, for better or for worse, the potential for this to get in front of the Supreme Court is concerning. I've been pretty transparent that I think that this court is incredibly activist, and I have a lot of concern with the concept that they will limit themselves to the holding that is asked. We've seen in numerous cases just in the last 2 years that precedent doesn't matter to this court, and they are willing to reshape and eliminate precedent as they see fit. And so I can absolutely see a scenario where this gets in front of the Supreme Court, and the court decides that they're not going to stick to the holding. They're just going to blow up the entire licensure system. And if that happens, we don't have a solution on the federal level. We certainly don't have a solution that can compete on the state level if that's gone. And I think that's unfortunate that we're moving forward in that way, with the risk that poses to patients and frankly to practitioners. And I will give an example. I think in 2016, the Texas legislature forgot to reauthorize the medical board, and medical licensure for 2 weeks went away in that state. And at first it was championed as we don't need regulation, but within 2 weeks, all of the non-regulatory actors who had pounded on the governor's door was able to generate a special session. And it was ostensibly not supposed to be about the medical board, but the first thing that they did was reauthorize the medical board. You have insurance, you have billing, you have tracking and accountability all tied to this. And that's the thing that can't be replaced yet. I think that there are certainly solutions. Compacts, I view it as probably an interim solution. But if I had my magic wand and a wish, I would create something like what the UK or Canada has, which is a national practice registry where you would be licensed in one state, and then through that regulator, you would get access to be practicing on the national registry and practice nationally. That still maintains a system. It's a hybrid. It doesn't stick the responsibility with the feds, which there are so many reasons that's not a good idea. And I think the primary one is, and I've asked this in numerous settings with clinicians, and the question is, how many clinicians are comfortable with their scope being redefined every 4 years by executive order by a non-clinician? And I never get someone raising their hand wanting to go to that model. There's always that concern, and I think post-Dobbs, it's a much greater concern. And the reality is, we have seen just in this year, in the last year, with the matching rates in graduate medical education, that anti-choice states are seeing a 6% decrease in matching to OB and family medicine because of the reduced scope that they're getting trained in these ACGME accredited residencies. So they're choosing pro-choice states so they know that they get the full scope training. If we're looking at a compound interest scenario, over the single cohort, you're going to see in these anti-choice states an 18% drop in trainees selecting their programs. That's huge, because when you extrapolate out to the 70% rate of trainees that stay in the place where they train, you're talking about a massive drought of practitioners, and most often they're going to be in more rural areas that are going to be hit the hardest. So with that, I will pass it back to May for the conversation.
Thank you, Micah. And if we can have Dr. Hughes and Caleb come back on as well. But Micah, I'm going to stick with you because this came up and you mentioned it a couple of times. Could you sort of explain a little bit further, like the impact of Dobbs? It was actually a question in the chat too, and they wanted just like a little bit further clarification, the impact of Dobbs on like this licensure issue.
Yeah, so I think we saw the raft of legislation sort of competing with Dobbs and then trying to enhance Dobbs, and not trying to pick on Texas, but they're easily the most notable with respect to what they passed. And so you've got those things where you can lose your license, you go to jail for 90 years, and you get $100,000 fine for doing any of that. And that's a pretty comprehensive approach, and that's their choice. But it's not as if their choices are not impacting others. And I'll give the example of our neighbor state, Idaho. They had the strictest abortion ban in the country come up once Dobbs went forward. And what we've seen is, and their AG refuses to acknowledge this, but the fact is we've got the hospital data, the transfer data, and everything else. They have had an amazing spike in pregnant women being life flighted out of there to Washington, Oregon, and Utah for abortion services that were life-threatening. They had 9 gynecological OB specialists in the state. They now have 3, and that's an Atlantic article from just last month. They have had maternal wards crater and close, and they are down to 1. So the reality of how this has impacted other states, it's not just Idaho and their people that got it. It's the pressures that go on to neighboring states that have to pick up the slack. Now, with respect to Washington, Connecticut, and a number of others, they have enacted laws that are designed to shield the practitioners that are licensed with them. I'm not sure if you lose the licensure structure on a state-based level, how you protect those licensees from predatory actors. There's not a great system set up to do that other than just pure legal.
Thank you for that. Caleb, we have a question here, and really about one of the more, at least when I first saw the filing for New Jersey, I was like, oh, I hadn't thought about that type of argument. And it's the First Amendment argument. I'm wondering if you can like go a little bit further on like how that actually, how that argument actually plays into the whole licensure issue. Sure.
So within that argument, no one is saying that telemedicine or telehealth is not the practice of medicine. What the challenge of a First Amendment claim like this is distinguishing between speech and conduct. And the courts have pretty uniformly said that just a state calling something the practice of medicine is insufficient for First Amendment purposes for something to be conduct and not speech. So what the courts are doing instead is it's a much more detailed fact-based analysis of what is the triggering event that causes a law's coverage. Is that actually like treatment, or is it speech? There was a case as recently as last week from the Fifth Circuit Court of Appeals based in New Orleans. There was a case out of Texas involving telehealth in the veterinarian context. And a veterinarian was providing generalized advice generally over email, and Texas prosecuted him for that because they had a in-person exam requirement. But when this case went through the courts for many, many years, and finally last week, the Fifth Circuit said, well, what triggered that was not actually treating animals, but conveying information that the owners could then take and do with what they would go see other local veterinarians. And so that's the kind of analysis that's happening. So in our case, the reason we say and we argue that what is triggered here is speech is because It's a consultation. It's not prescribing. It's not talk therapy. It's not primary care over telehealth. It's just a conversation that could lead to in-person treatment, which would, of course, be conduct. If instead this was a context of telehealth being used for talk therapy, then because the speaking is actually treatment, there are some courts, including the Ninth Circuit, which covers California, have said that falls on the conduct side of the line. So when you're thinking of, well, even though I say this case is really narrow, how could this impact other things like psychotherapy? That's the kind of analysis that the courts are going to make. And depending on where you are around the country, courts do view it differently. And so I'll leave it at that for now.
Thank you. Dr. Hughes, Micah mentioned this. It's like, what are your thoughts on like that national approach? Like if there was some sort of national registry set up where practitioners can like go through that as opposed to like getting individual licenses in individual states.
Yeah, I think that's great. I was going to applaud that idea. I think the devil's in the details. I mean, ideally, that's what the IMLC could have been, but it's essentially almost as much work to do that process for each state than it is. So I would totally applaud that if it was relatively easy, relatively cheap. I mean, I think if it's instantaneously national and it's for telehealth only, there could probably be some reason to pay $200 or $300 to do it, and maybe to do fingerprinting if you only have it to do it once for all 50 states. But yes, I mean, that would absolutely be a great solution to what we want to see. I think for the VA and Sports Medical Clarity Act, I don't think there's a very clear outline in the law, and I'm not a lawyer, of what happens when something goes wrong. Those are kind of more contained areas. You know, the VA could fire a VA clinician. Sports Medical Clarity Act, that sports traveling doctor is going to travel back to the original place that they're traveling with. So I liked the idea of a national registry having the potential of being taken away. If someone's a bad actor, it kind of solves that lack of clarity about what happens. My concern is, do people have to sign on to it? Because I think that's what we've seen, that, you know, the Uniform Telehealth Act makes a lot of sense, but states aren't passing it, you know, or haven't yet. So how could it be that federal precedent around some of the things that Caleb's talking about could lead to a national registry that clinicians can opt to participate in, even if their state doesn't participate in it?
Slightly off track, but kind of related to this, if they ever do it, there is in federal law a requirement that the DEA create a telehealth registry when prescribing controlled substance. I mean,
I can speak a lot to that, May.
Go ahead, Micah.
Yeah, that's a cluster right now. And I don't think there's a better word that's not an expletive to say. So if you've been following this, the DEA has been ordered for, I think, a decade to create this thing, and they still haven't. And there's been, you know, if you follow the creation of federal law by Congress and how disjointed it is, the fact that they have successfully passed, I think, 3 different times an order for the DEA to put these rules out, and they still haven't. There's currently a disagreement between the White House, DEA, and HHS. And someone can correct me on the correct nomenclature, but after having viewed DEA's proposed regs, HHS did what was effectively a non-consent, we don't agree, we don't like these rules that are coming forward position. As I understand it, a lot of the positioning and so-called guardrails that DEA is trying to put up are being driven by White House policy. And so, unfortunately, that's where that's at. There is an effort to try and make them publish the rules so we can at least see what they're talking about in writing. Because right now it's coming from inside sources who retired from the DEA. And but I can say that based off of the briefings that I've attended, it's incredibly restrictive. It will destroy. In Washington, for sure, it will destroy the ability of long-term care facilities, nursing homes, and others to function, because the proposed rule assumes that team-based practice does not occur, and that's the only way that those things happen in Washington State, and I'm sure in other rural areas of the country, that's how it works as well. The other piece is that for no no reason whatsoever. There's no data to support this, that they put a 50% limit on your practice being telemedicine. And there's a requirement to check every state PMP if you're going to prescribe a controlled C2 substance via telemedicine, which again, to me is insane.
Dr.
Not only
Hughes.
insane- Yeah, not only insane, not possible to check all 50 states PME, like not
Right.
technically possible. So totally agree with Micah's cluster point. I would also be interested to hear both of you on, I guess, from a driver's license analogy standpoint. I think the way that a lot of states ended up joining whatever driver's license compact is that, you know, state funding for highways were tied to it. I don't know if there's any thought to how to incentivize states to participate in some sort of nice national registration.
Yeah, I mean, as I've kind of gone over the concept of the registration, it will take a small piece of federal legislation to require states to join it. I think the ideal scenario is some kind of a public-private partnership where a national organization runs it, but the governance is done by the regulatory bodies at the state level. So, and that's really how it works in other countries. So it's not like we're reinventing the wheel. What we're talking about is taking the wheel and making it bigger. You look at Canada; they've got a provincial registry. Australia actually does have a fairly national registry. It was created in 7 of its 8 states via legislation, and then a memorandum with that 7th state, and there were some intricacies there. But yeah, I think the main issue there is transparency. There's certainly some functions that could be enhanced if you go this way, like a national complaint portal. So I mean, I think that's a big benefit that solves a lot of our jurisdictional, how do you find the doctor that treated you questions. Funding is still there, but I think you can easily address that through a number of different functions and not at the federal level.
I guess just to add to that, I think the flip side of our dormant commerce clause argument is kind of assuming that there is a congressional power and authority to supersede state licensure. As I think Micah and even you may have touched on this earlier today, that state licensure of occupations and professions is historically a state role and function, and I think that's largely correct under the structure of the Constitution's separation of powers and authorities. But inherent in our argument that interstate telehealth, particularly in the specialty context, it is crossing state lines, and state restrictions on that aren't just affecting physicians and patients within one state, it's applying across state borders. Because of that situation, I think an argument can be made that Congress would have the authority to create some kind of national licensing scheme, at least for telehealth specifically. Now, what the specifics of that would be and how that would function is beyond my expertise, well over my head. But at least from a constitutional standpoint, I think they would have that authority when we're just talking about interstate telehealth.
Micah, you kind of look like maybe you wanted to add something to that, or? No.
I would say that I'm always going to be against a telemedicine specific license. The license needs to function in the full scope. So if you're going to have one, then it needs to be a full scope license because you introduce so many complexities and so many potential roadblocks if you're trying to say, well, you can only practice telehealth here. And as far as the speech harm issue, I'll just transparently say I think that telemedicine practice, like medicine practice, is speech incidental to conduct. And as someone pointed out in the chat, the quote experts in California had a number of them who were high profile that talked about COVID treatments that were erroneous. There were a number of patients who were significantly harmed, and unfortunately, a great number of them are not here with us anymore to speak about the harms.
Well, we are almost at time, but I just wanted to ask Caleb, just really quickly, you mentioned like these cases really are at the beginning. They're fairly new. There's still like a process to go through that they would need to go through. But about how long is this where you think, let's just say the cases aren't thrown out, they're not dismissed, and they go through actually being heard in court and everything. About how long or when will we expect maybe some movement in that? I know it's kind of like a guess. It's like the courts are deciding that, but just like on average.
Sure. Well, I can't provide an average. The federal courts have no rules on how long they have to take, unlike a lot of state courts. As an example, I have a case completely different from these kinds of cases. I argued this in the Second Circuit Court of Appeals in New York 2.5 years ago, still waiting for a decision. Nothing I can do to speed it along whatsoever. It's just up to them to issue a decision. District courts usually don't take that long, but I would say if we assume that either one or both of them are not dismissed and we proceed to discovery, because of the way these cases are designed, they're not incredibly fact intensive. They're not going to require a year of depositions and various other discovery. That would just be a matter of some months before they would likely move to what's called summary judgment. In cases where there aren't a lot of facts in dispute, it's just a question of whether a law is constitutional or not. You don't need to have a trial. You can just say, you basically come to agreement on what the facts are, and then the judge decides the constitutionality of the law. And that's fairly typical of public interest cases like this. And I would say it would be reasonable if, say, a motion to dismiss in one of these cases was denied this week and we were able to begin discovery this month. I would expect a decision on summary judgment within a year. And then depending on the outcome of that, if one of the parties decided to appeal that, depending on where that is, that is going to the time that an appeal would take would vary. If it was the Ninth Circuit with the California case, they have such a heavy caseload that things tend to take a bit longer there. But if it was the New Jersey case, which is the Third Circuit Court of Appeals, they don't have quite as heavy of a caseload. So I would say from a denial of a motion to dismiss to moving into discovery to the end of an appeal, I don't think 2 years would be out of the ordinary. And at that point, of course, there would be potential for Supreme Court review. But I did just want to touch briefly on that since Micah mentioned some concerns with the Supreme Court. Having worked on what we would call economic liberty type cases, and by that I mean cases where professionals are challenging restrictions on their ability to engage in their profession. Having done that for over 9 years, and PLF, my organization, has been doing that for decades, as well as others, I can say with confidence that the Supreme Court on these kinds of issues is in no hurry to upturn decades of precedent. As recently as last year, there was a similar-ish case like this that presented an extremely sympathetic situation, and it was denied without even comments. So we don't need to get into the weeds now, but I just wanted to say that I do not share Micah's concerns about, even if I agreed with him that the court was activist, but I just don't think that there's great upheaval afoot in cases like this where professionals are challenging restrictions.
All right. Well, we are at time. We're actually slightly over. So thank you, everyone, for staying on here just a little bit longer. I wanted to thank Dr. Hughes, Micah Matthews, and Caleb Trotter for this great webinar and this great presentation today. I found it very informative, and I'm sure our audience did as well. If we can go to the next slide, just a couple of things to wrap up. We will have a recording of this webinar available on the CCHP website. Give us about 48 hours to get that up. We'll also have the PowerPoint available as well, and we'll make sure to link Dr. Hughes's video so you can watch the full video as well and access it that way. If we can go to the next slide. After you log out, you should get like a short evaluation from a survey. If you could just fill that out, that would really, really help out CCHP. Thank you again to our panel panelists, Dr. Hughes, Caleb Trotter, and Micah Matthews. And thank you also for everyone who attended. Hope you have a great day, and we will be seeing you soon, hopefully on another webinar. Bye-bye.